Hello, my name is Andrew Griffin and I am a bankruptcy lawyer in the San Diego area. And today I would like to talk to you about the questions many clients have about meetings of creditors or 341 bankruptcy hearings in the Southern District of California. If you have any questions regarding your unique situation, pick up the phone and call us. We can help you figure out your options. The bankruptcy meeting of creditors may be a daunting prospect for debtors. It is common for my clients to ask me, what questions will they ask me at the court hearing I must attend? How long does it last? Will the judge deny my case at the hearing? Do I really need to attend? These questions and many more seem to be asked by every debtor I meet. So let's get to the bottom of this and explore the meeting of creditors for debtors in the Southern District of California. The meeting of creditors, or the 341A hearing, the technical term of the hearing under the Bankruptcy Code, seems to be the most feared part of bankruptcy for the majority of the clients that I see. But the truth is, the creditors meeting is generally the most non-eventful part of the bankruptcy case. Yes, you must be physically present and must physically attend unless you qualify under one of the four exceptions. 1, you're dead. 2, you are in prison. 3, you are in military deployment. Or 4, you are medically unable. Unless you qualify under one of these exceptions, you will need to be at the hearing, which is scheduled approximately 30 days after the bankruptcy case is filed. How long does it last? Well, it depends. I've seen some last under 30 seconds. Others I've seen last over an hour. The majority of cases, about 90%, generally last 2 to 4 minutes each. There are about 12 to 16 cases called each hour, on the hour, generally from 9 a.m. to 4 p.m. Some trustees are quick. Some are generally extremely slow. Regardless of which trustee you get, the results seem to be the same. Chapter 7 cases are generally quicker than Chapter 13 cases. In the Southern District of California Bankruptcy Court, there are 6 Chapter 7 trustees and 2 Chapter 13 trustees. There are 2 very super fast Chapter 7 trustees. There is 1 extremely slow trustee. The other 3 are somewhere in the middle. There is no judge present at these hearings. That would be unlawful because it is forbidden in the bankruptcy rules. In most cases, you will never see the judge. Rather, you will meet your case trustee at the hearing. All the trustees here have financial backgrounds of some various degrees. Some are not even lawyers. Many of them also file bankruptcy cases for other debtors as well, and will sit with their clients before other trustees with all the other attorneys. Sometimes the meetings are continued. Generally, your attorney will be able to give you a heads up if you can expect a continuance. Now, the most common reasons for a continued hearings are a debtor that does not show up or shows up late, the failure to list all your assets, the failure to send in supporting documents to the trustee, the failure to list all your creditors, if the credit card debt is over $100,000, the failure to bring a government-issued ID and proof of Social Security number, and higher than normal or higher than usual income. Now, what type of questions do they ask? So who's present at these hearings other than the trustee? Other debtors and their attorneys. Very rarely will a creditor show up, even though that's the name of the hearing, a creditor's hearing. This is because very little can be done by the creditor at the hearing. Generally, if a creditor has a problem with your case, it will not take place at the creditor's meeting, but rather in the actual bankruptcy court and after a separate lawsuit is filed. Also, even now, every now and then, an additional person from the United States Trustee's Office may come in and ask a few questions to individuals with higher than usual income or debt loads. It's a very busy place with 30 to 60 people filtering in and out each hour. Debtors come in, they come in from all walks of life. Some are in wheelchairs, others do not speak English, some are teenagers, others are in their 90s. No one is immune from the bankruptcy, and by the same token, immune from those hearings. So what will they ask? As far as San Diego is concerned, expect the following questions. State your name and address for the record. Did you list all your assets? Did you list all your debts? Did you list all your income? Is there any reason to make any changes to your schedules? Have you just transferred any property or money to any family members in the last year? Are there any creditors present? No? Thank you. Your meeting is concluded. Next. And so it goes. One time I've seen a trustee locally conclude 15 of my hearings in 20 minutes. It was like a cattle call. I could not even keep up with the moving one file off the desk before I could put the next file on the desk. The bottom line is that these trustees are only doing their jobs. A Chapter 7 trustee gets $60 per case to handle. It comes out of the $335 filing fee, or about $900 per hour on the calendar. They rotate during these hearings every couple of weeks, and so $900 times 6 hours times twice per month is $10,800 to run their entire office and staff. It's not much. That is why their biggest focus is on the unwary that have too many assets. If they sell an asset, the trustee gets 25% of the first $5,000, 10% of the next $45,000, 5% of the amounts past $50,000. Collect $100,000 on a case, and they get $8,250. So just one Chapter 7 case with a $100,000 asset is like doing 137 hearings. Now you really know their motivation. So what's the bottom line? Prepare for the hearing. Spend at least an hour going over your bankruptcy petition and schedules. Be intimately familiar with those as well as your income for the last 6 months. Always, always, always tell the truth. Don't hide anything. Be straight. The trustees have presided over thousands and thousands of hearings. They can smell an honest debtor from one trying to play tricks. As long as you tell the truth and follow your attorney's advice, it will be over quicker than you know. If you need more information about filing bankruptcy, click on the link or call us at the number below, and we'll be glad to provide you with more information. My name is Andrew Griffin, and I want to help you by relieving your financial burden.